What is up, everybody, and welcome back to the Fresh Finance Podcast. My name is Thomas Elms. I've got my co-chair, Kyle Ryan, and today we are excited to have our second guest on the podcast. We've got Sal Bello, who is an associate estate planning attorney in the Pennsylvania, kind of the Philly area, and he works at Bello Riley McGrory DePippo PC in the Philly area. And today we're really just going to kind of have a really in-depth conversation on the general dynamics of estate planning. Sal, we're really excited to have you on. Kyle, before we kind of dive into Sal's intro, would love to just kind of get your thoughts on the conversation, estate planning, and especially kind of the tilt that we're going to take to it today, which is kind of that beginning stages of estate planning and what's important, and some of the life changes that we're going to kind of talk through that might require some additional estate planning. Would love to just kind of get your initial thoughts on the conversation.
Yeah, thank you, Thomas. I'm really excited for the topic today. I'm excited to have Sal on. Thank you for joining us, Sal. One thing I have to note, this isn't an endorsement of Sal, of course. This is just having him on for educational purposes, because today we're talking about estate planning, specifically wills, why we think everyone needs them, what benefits they can have for you, getting a little bit into trusts, but really, talking about everything estate planning as we believe it applies to our listeners.
Perfect. And Sal, we kind of introed you here at the start, but would love to just kind of have you intro yourself, maybe even how you got into the industry, and kind of what you're working on with clients, and then we can kind of, work through the conversation.
Yeah, sure. Absolutely. Thank you both for having me here. I really appreciate the opportunity to come on here and speak about a topic that I think is of a vital importance to, people our age, people younger than us, people, older than us as well. Right. I think
Absolutely.
that estate planning is something that's essential for everyone, regardless of age, and familial circumstances for a variety of reasons. But just to give you guys a brief intro about me, my name's Sal Bello. We work in the Philadelphia suburbs area, right? We're a general practice firm. I started, my legal career at the Philadelphia District Attorney's Office, prosecuting, felony and misdemeanor criminal, cases. Okay. Just to back up briefly, I was in college, right, at Ursinus College. That's a Philadelphia suburb, small liberal arts college, right? Initially wanted to be a doctor. Organic chemistry told me that I was not going to be a doctor.
Oh yeah. That was like me. I was originally going to be a mechanical engineer, and I got to physics for engineers 1 and decided that this is not the trajectory I wanted to take.
Right, exactly. So that was a quick bump in the butt to get me moving in a different direction, right? So
yeah.
I quickly switched to economics, where, quite frankly, I felt really comfortable and excelled in a variety of different ways. Coming out of college, I truly didn't know exactly what I wanted to do. And one of my economics professors that I actually was a teaching assistant for said, Sal, why don't you just give, law a shot? Why don't you take the LSATs and see what happens, right? And, kind of the rest is history after that, right? She kind of gave me the bump that I needed, and I took the LSATs, got into Drexel Law, Thomas R. Klein School of Law, spent 3 years there. I graduated, found myself at the district attorney's office, right? Loved my time as a prosecutor there, had the ability to, get up on my feet, argue in front of, some tough judges and some tough defense attorneys in the area, right? And really felt comfortable doing that. Shortly thereafter, right, I always had the dream of joining my father and his firm, right? Once I decided I was going to be an attorney, I knew that this was always going to be my home at some point. That opportunity just presented itself in a different time than I originally anticipated, right? We had a longtime associate that ended up going into private practice, and they said, hey, Sal, well, you got to come along a little bit sooner than, you thought. And
Perfect.
Kind of that's where I've been for the last 2 years. I'm coming up on 2 years in May. What we do here, like I said, we're general practice. And what that means is we do a variety of different things. There's 4 different partners, main partners, Bello, Riley, McGrory, and DePippo. They all have their own specialties and their own areas of practice, right? Primarily what we do with the firm is criminal defense, family law, personal injury, and estate planning. Okay. We also do general litigation and business disputes, transactional law as well. My dad kind of specializes in that more so than anyone else. And he's also a solicitor for the borough of Bridgeport, right? Handling municipal law, right? So we really do have a mixed bag over here. But one of the first things that I did when I got here was learn how to draft wills and power of attorneys and living will documents, right? Because, the partners said, Sal, you're going to meet a lot of people, right, throughout the course of your business. And one of the most important things you need to impart on them is the ability to have estate planning. So that way they can prepare for their future, for their now, and for their children and their grandchildren and their spouses when the time's right.
Yeah, absolutely.
So that's kind of a little bit about me, right? I am very comfortable with this conversation, right? Because I do draft several of these per week.
Yeah.
And I do have these, certain spiels and packages that I sell to my clients because I do recognize the value in having a will, a power of attorney, and some sort of advanced healthcare directive or living will document, right? And now, I had this conversation with Thomas and Kyle, kind of off the podcast before we got started here, guys. And, the reality is that everyone should have a will, right? You're really not too young to have a will. Look, if you don't make any money and you don't have a job and you're still in school, I think, we can all agree there's probably not a whole lot of benefit to it, right?
Yeah.
The minute you get out into the, working world and into the workforce, you really should consider doing so, right? And here's why, okay? You're going to work your entire life, right? You're going to be taxed on, a variety of different things for working. And then, unfortunately, the state of Pennsylvania is going to tax you again when you're dead.
Yeah.
Okay? That's the unfortunate reality of what we're dealing with here, right?
Yeah.
And something that people need to understand is that you want to make sure that everything that you've built throughout your life, presently and into the future, is going to the people that you want it to go to, right? And, I've seen a lot of different clients with very specific things. I've seen people with expensive Ferraris, and I've seen people with, card collections that might be worth like $10 or $5,000, right?
Yeah.
Yeah.
Everyone has things in their life that are of either monetary value or personal, value. And that needs to go to the right individual, right? And it needs to be sure, you need to be sure that if Pennsylvania is going to assess state inheritance taxes on it, that individual knows about it and that they're receiving the benefit of it despite the taxes.
Yep. And I always like to say, would you rather you decide where your assets go or let the lovely state of Pennsylvania determine that?
Right.
And if you want to choose, it might be worthwhile getting a will.
And that's absolutely just it, right? When you die without a will in Pennsylvania, it's called dying intestate, right? That's INTESTATE. Okay. And that basically means that you don't have a will. And I'm not going to go into every complexity associated with the intestate laws because there's a plethora of different scenarios that we could bump through, right? And we could probably spend an entire podcast talking about just that area of the law, right?
Yeah.
There's different scenarios that happens if you have a spouse and you die without a will, if you have children when you die without a will, if you have no spouse and no children, right? And you have parents, right? All different ways that the state is going to essentially say, this is the way that your money is going to be distributed, right? And you want to make sure that we can avoid that at all costs, right? Because that's the state making a decision for you with the money and the assets that you've accumulated throughout your life. And I think all of us can agree that we don't want that to happen unless it's an accident.
Yep. So Sal, can you speak to us a little bit more about what would be covered in the will and what is the difference? Because I run into this question a lot, right? If you have beneficiaries, say on an investment account, you have a TOD, a POD on a bank account, you have a joint registration on your bank account with your spouse or something like that. Can you explain the difference of what makes it to your will and how things that are titled or have beneficiaries don't?
Yeah, absolutely. So before I even go into that, I want to just discuss a little bit of brief vocabulary, right,
Yes,
for everyone here. Absolutely. So when you have a will, right, the first thing that you're going to do is you're going to designate what's called an executor or an executrix. Okay, an executor is a male, and an executrix is a female. All right, it's the exact same function with really no distinction other than the spelling of the names, right?
Yep.
Yeah.
What you're also going to generally do is you're going to designate an alternate, okay, an alternate executor or executrix, okay? And what that's going to say is essentially that if the person that is originally appointed dies, renounces, or resigns for any reason, that alternate's going to step up, okay? And so the reason I bring this up, right, is because whoever you designate as that executrix or executor is going to be in charge of administering your estate. okay, and ensuring that your estate assets go to your designated beneficiaries, like Kyle said. And he used the term beneficiaries, right? And that's who's going to receive your assets and your property at the time of your death, right? A lot of times it's going to be lineal descendants or heirs, right? But it can be a friend, it can be a sibling, it can be a grandparent, or, a cousin,
Charity, something like that. Yeah.
a charity, right? It can be any of those things, right? So what's important and kind of circling back to Kyle's question, right, about designating certain things and what is and isn't protected, right? There's certain things that are going to go directly to spouses, right, or to children that are called probatable assets. Okay. There's also non-probatable assets. Okay. So I want to take one, brief example of a non-probatable asset in Pennsylvania. Okay. It's a spouse to spouse transfer of a property. Okay. When in Pennsylvania, when you get married and you obtain a property during the marriage with your spouse, Pennsylvania is actually only one of 4 to 5 states left in the United States that has a longstanding doctrine called tenancy by the entireties. Okay. And what that says is that basically your property is retained by husband and wife, right? So if I have a property with my wife and I die, the will doesn't even really need to designate anything, right? She's automatically going to retain that property because she's a 1/2 owner as a tenant by the entirety.
Mm-hmm.
Right? So that is a non-probatable asset, something that is not going to be assessed for Pennsylvania state inheritance tax. In fact, anything given to a spouse in a will is actually assessed at 0% for Pennsylvania state tax, right? So it's something that's incredibly important for people to understand is that, look, hopefully there's trust between you and your spouse, but the reality is that if you can give as much to your spouse as possible, you are protecting yourself from saving a lot of money.
Absolutely. Absolutely. That's really great. So in terms of where do you really see the need? When do you see most people come to you and starting to get that will? When do you see people start to get a will? When do you see significant life events in which people should update their will? Because I've run into it plenty of times. Oh yeah, we have a will, but we haven't looked at it since we first had kids.
Right.
So when do you really see those time horizons happening?
Absolutely. So that, yeah. And circling back to what I said, a little bit earlier, right? About, saying graduating from school, graduating from high school with a degree, and you get out into the workforce and you're starting to make, your first chunk of change, whatever that might be, right? That's when you want to first start thinking about, okay, do I need a will? This money that I'm accumulating, who do I want it to go to, right? Other major life events are getting married, right? Accounting for your spouse and making sure that the monies that you and the assets that you accumulate are going to your spouse. The birth of children, right? That's another massive event.
Yeah.
The death of relatives, right? Or the death of any spouse or children is a massive life event. Any large inheritance that you may get, right? You want to make sure that that's protected or at least being given to the people that, you want it to go to in the event of a catastrophic injury, right? The tough thing about these conversations, guys, and especially for people that are our age, right, is that we kind of live in a world where we say nothing's going to happen to me, right? If I cross the street, I'm not going to get hit by a car, right? I'm not going to get into a car accident. I'm not going to get hit by the drunk driver, right? The things that are tough for my clients is having these kind of morbid conversations, right?
Yeah.
You're a 45, 50-year-old male or female, and you have children that are, under 18. Nobody wants to talk about what happens if their children die before they do. Right. But these are things that need to be discussed if we're going to adequately plan for the future, because if your money's going to be dispersed to one of your children and you don't have a plan as to where it's going to go if he or she doesn't survive, that's a problem. Right. And then we're talking about the state jumping in and taking money that they don't deserve.
And if you want to direct how your kids are going to be taken care of, you have dependent children and you might not have a good relationship with your siblings and you want your parents to take care of it. You don't have a will. The state gets to decide that.
That's absolutely right. And that's incredibly important, right? And that kind of leads us to the next topic, right? Which is designating a guardian.
Yes.
Right, in your will, right? And for people that have young children, particularly those that are under 18, obviously once you turn 18, you age out of that provision, right? But, if you have a spouse, obviously the first person that's going to have the ability to care for your children is your spouse if you, in the event of your death, right? But, you know, again, these morbid conversations, assuming that both of you are deceased and you have children that are under the age of 18, you want to be able to designate who it is that is going to take care of your children, who's going to provide them maintenance and support, where are they going to live, you know, what's their educational needs, right? You can specify it or make it as broad as you want, right? There's benefits, pros and cons to doing both, right? You know, again, we could spend hours talking about the benefits of, you know, where you choose to educate your children, right? Or where they choose to live and which school district they choose to live, right?
Yeah.
The problem with specifying a lot of that are circumstances change, right? You know, where someone's job, your guardian's job, doesn't allow you to transport them to the school district that you decided that they were going to live in, right? Those little things come up, right? So I tend to tell my clients, look, the most important thing you need to do is determine that there's somebody other than your spouse that you trust in your life to care for your children and give them the life that you thought that you were going to be able to give them in the event that you would pass.
And I think one thing you said, I want to hit on that. Now we're talking about caring for your dependent children age 0 through 18. Now, once a child reaches above 18, a lot of parents don't realize that, say they got into a medical accident and they were incapacitated. Once you reach above the age of 18, you no longer have that, you know, that power of attorney, the power to make medical decisions on behalf. So that I've heard people talk before, you know, for your 18th birthday, get a medical POA for your kid.
Yeah,
Right. Can you
absolutely.
speak to that a little bit? Why might someone consider that? What happens when you turn 18 that you might want to consider that?
Absolutely. And, you know, that brings me back to a client I had a few months back who actually got one for her son because, you know, they're local Pennsylvania, you know, people here. Son actually went out to USC for college. Right.
Yeah.
And mom said, Sal, you know, I really want to get a medical POA. You know, I'm thousands of miles away from my son. I want to make sure that he's protected and, you know, I can make decisions if, you know, God forbid something happens to him. Right. That's a problem.
Absolutely.
So, you know, a lot of people don't understand the distinctions of power of attorney, right, versus the executor and executrix in a will, right? And I'll give you just a brief synopsis of the distinctions, right? The executor or executrix in your will is, as I said before, in charge with administering your estate, right? That's taking your assets, making sure that they go to the correct beneficiaries, making sure that your assets are assessed for taxes if applicable, right? And distributing them and essentially closing the estate. Okay. That person operates when you're dead. Okay. Only in the event that you're dead. Okay. They will not have any power to do anything to your estate while you are still living. Okay. That's distinction number one. Now, your power of attorney actually only operates while you are living. Okay. Whatever that state may be. Okay. The power of attorney document or the power of attorney power ceases the moment you die. Okay.
Yep.
And the main reason for getting a power of attorney, right? There's a durable financial power of attorney, a medical healthcare power of attorney, and the way we have it actually in our firm, an individual that often serves in both capacities encompassed into one document.
Got it. And, you know, one of the things that I kind of always talk about when we have the conversation on, you know, morbid conversations with people, and this is kind of the reason why a lot of people kind of shy away from this conversation, is the way that I kind of prepare this conversation is, would you rather have a hypothetical conversation where we put it in place now, or would you rather have to deal with it if it actually happens in the moment? Right.
Yeah.
And, excuse me. And normally that hypothetical conversation is going to be much easier to have and much easier to get in place than having to try and deal with all of these things in the midst of a disaster.
When
Right.
you're emotional. Yeah.
Yeah, exactly.
Right.
And you're trying to go through these like you said, go through these emotions and try and catch up, because that's the big thing is once it's happened, you're too late. Right. Because if you have a child who is 20, you didn't have them set up a new healthcare directive and they get in a major car accident, you now realize in the hospital, hey, these doctors are telling me I actually can't make decisions for him. Right. It's too late.
Those doctors are liable too.
Exactly. Right? And HIPAA is as in-depth and as rock solid as we either want it or not want it to be, depending on our situation. It's just a fact of the medical system in the United States. But that's the conversation is, Would you rather have this morbid hypothetical conversation where we can plan all of this out, get all the structure and the documentation in place, or would you rather try and deal with this in the midst of disaster, and in the midst of chaos? And I think once you kind of phrase it in that type of a light, a lot of people are much more comfortable in saying, you know what, let's just go ahead and get this done.
Yep.
Absolutely. And that's certainly the case. I think it's a great way to describe it, Thomas, to tell you the truth. It really is.
And to kind of sorry to cut you off there, Sal, just kind of recap here. So as we kind of move through, I'd call it the chronology of somebody's life. You get out of college, let's just say, and you start your working career. This is the time where you want to set up the will. I'd also say, kind of in reference, if you're setting up your own bank accounts, make sure you have payable on death forms. If you're applying for that 401k at your job for the first time, make sure you set a beneficiary, whether it's a parent or a friend or a loved one, however you want to set that. Make sure you have beneficiaries on your 401ks. If you're doing any investing outside of that, make sure you have beneficiaries. If you purchase a home and you're not married, in the state of Kansas, we look at beneficiary home deeds, things of that nature. That's maybe when a will comes in as well. And then kind of life events that you've talked about that would require some updating are if you get married, each time you have a child, if you receive an inheritance. I think another important one that maybe, Sal, you could provide some guidance on, even though you're kind of operating in the state of Pennsylvania, is if you move, because I've actually had a lot of clients that have moved from the state of Kansas to the state of Texas. They're doing it primarily because it's nicer, weather-wise, at least a little bit, but also there's no state income tax. But one of the things that a lot of people don't recognize, and correct me if I'm wrong, but Texas is a community property state. And so there's some differences in the estate planning laws from state to state. And so recognizing if you're making a move to a different state, you might want to kind of get a reevaluation of your estate plan, because some of the laws in that new state might change things.
Yeah, Thomas, absolutely great point that I neglected to hit, right? If you change states, if I prepare your will in Pennsylvania and you move to New York, you should immediately contact a New York estate planning attorney. You should get yours done, and then once it's finalized, you should tear mine up immediately. Okay? and that's kind of, that's the reality of the situation, right? And I would tell that to any client, right? My services become obsolete once you change my state. Okay. And every single state has specific laws. Intestate laws are different in every state. Like Thomas said, property laws are different in every state. The taxes can be different in the states, right? So you want to make sure that you consult with a professional in your home state, whatever that may be, right? And if you're a person that, you split some time in Florida, but your primary residence is in Pennsylvania, or, whatever example you want to say, right? That might not necessarily apply to you. Okay. If your home state is Pennsylvania and you spend some time elsewhere, right? You can still handle the distribution of some of your property outside of the state, right? But it's not necessarily recommended. Okay. And you want to make sure you're going to somebody that you're comfortable with in the state that you then live in for that purpose, for sure.
Yeah. I've got something off topic, but just jumping on what you just said, Sal, say you live in PA and you have a Florida vacation home. At your death, if you say, depending on certain situations, what happens with the Florida vacation home? Does that go to probate law in Florida? Are there ways to avoid that? Do you have any experience with that?
Right. So, and I'll tell you, generally, we will actually partner with another firm in the other state to ensure that we're going, through the right process of probating the assets in the correct manner. Right. And, that's something that I would say goes without saying for people in my profession, but not necessarily everyone knows, right? If you're a doctor, right, you get to practice anywhere you want. Doesn't matter whether or not, you were licensed in California or Pennsylvania. You're a doctor, you're an MD, that's what you are.
Human body's the human body.
Human body's the human body, right? There's 50 states, there's 50 different jurisdictions, 50 different bar examinations that an attorney would have to take. Right. So for me to sit here and say, I need to be able to explain Florida law to my client would be actually potentially undergoing the unauthorized practice of law. Now, can I provide articles? Can I provide research? Can I explain what my thoughts are? Absolutely. But in terms of giving legal advice out of state in a jurisdiction that I'm not licensed to practice, it's totally unauthorized and honestly ill-advised. And if you're somebody that's having a conversation with an attorney that is licensed in Kansas, but he's giving you, information or advice on California law, that should raise an immediate red flag for you that this guy is actually he's trying to plug you along because he doesn't really know what he's talking about. And if he does, he probably read it on Google 20 minutes before you came in.
Yeah. Yeah, that's the harsh reality. And I think too, just going along the idea of how little, honestly, and I'm sure you could echo this, but how little people to actually do estate planning. The reality of how easy the process actually is. Because I do a lot of work with an estate planner in my area, with helping my clients draft documents. Really, the bulk of the time that comes into place is the thought that needs to go into it. I think that's the biggest thing. The actual paperwork, the conversations, the drafting, it really doesn't take that much time. But in all reality, it's really just the thought that comes into, hey, who do I want to be a guardian for my dependent children if my spouse passes away? Who do I want to make this beneficiary? Who do I want to make that beneficiary? And also just kind of gathering the knowledge base of kind of what's important. But the actual process of drafting the documents is really not that time consuming, at least in the experience that I've had. Now, obviously, as your estate becomes more complex, there's going to be more questions that need to be asked and more time that's needing to be had on that conversation. But for most people, the estate planning process, once you get the bulk of your documents down, it's really just up to updating as needed when life changes occur. And it's just there. It's there and it's ready. I'd also say another thing that is important from a change standpoint that you'll want to make adjustments is if estate planning laws change. And I think kind of a key one here that Kyle and I have talked about in the past, but the Tax Cuts and Jobs Act said the estate plan or the estate tax level at a certain amount it's sunsetting. Kyle, is it 2025 or 2027?
End of 2025, starting 2026. Yep.
End of 2025, and that's going to adjust the estate tax back to the original amount, right? So having conversations on that, if we see anything else come into play, but that's also why having an advisor who's kind of in touch with that, but especially an estate planning attorney that you have a relationship with, where if they're in your estate and something changes, they can reach out to you and say, hey, this change has been made and it might affect you in the future. We might want to consider updating this.
Yep.
Absolutely. And something, Thomas, I just want to hit on, real quick that I think is important for the audience to know and be aware of, right? I know it sounds like I'm trying to pull more money out of people's pockets when I say this, right? But the reality is that most attorneys have tax experience, but they are not CPAs, okay? And they are not accountants, and they cannot give you the maximum financial tax advice that you need, right? And so it's important for you to understand, unless your attorney is somebody that markets themselves as a tax planning advisor or someone with a CPA that only exclusively does tax law or has a background in tax, you really should consult with your own independent accountant.
Yeah.
Okay? As well, along with, your estate planning attorney. Look, my estate planning attorney recommended XYZ. What are the tax implications? Because he told me this, right? Mm-hmm. Those conversations should happen, right? And I understand CPAs, tax planning services, it's expensive and it can get expensive. And I think we're really more so talking about the more complex estates, right? Where you have a plethora of assets, right? That you're concerned about the tax ramifications for. Okay. Yeah. If you're, a guy or a girl that has, a single family home, you have a 401k, and you have, some checking and savings accounts, maybe a nice car, right? You don't necessarily need to go and contact your CPA and make sure that your estate planning attorney is doing the right thing. But, you have multiple businesses, you have multiple properties, you have things titled in different names, in LLCs, partnerships, corporations. Make sure you get on the horn with a CPA who's going to give you the best advice possible on that. And ideally, 2 financial planners as well.
There you go. There's the plug. Yeah. Whenever we, speak with a client about, wills or especially trusts, we speak a lot with our clients about trusts, but we always tell them we don't write wills. We don't draft trusts. but we do try and bridge the gap between us, the client, and the estate planning attorney, so that the client, sometimes, not that you would ever, but sometimes a lot of these terms can go right over someone's head. They don't quite understand it. So if they can go into a meeting with their estate planning attorney more prepared, already think about what they want. Do I want this sort of trust which can, get X, Y, and Z for me, irrevocable versus revocable. So having that conversation with the client, just with an accountant, a financial advisor like ourselves before they go to the estate planning attorney, can always, just give them a little more clarity.
Absolutely. Absolutely. And
Yeah.
one additional thing that I think is important, and it's kind of tangentially related to what you're saying, Kyle, is making sure you understand what probatable and non-probatable assets are, particularly in Pennsylvania, right? And like I said before, I can't speak to every other state, right? But the reality is that your property, your real property, your automobiles, your furnishings, your checking and savings accounts, and any other, tangible personal property that you own is what's known as a probatable asset. Okay. In Pennsylvania, we say that passes through the will. Okay? That means that the will directs how those assets are distributed and to whom. Okay. Well, on the flip side of that coin, there are things called non-probatable assets that in Pennsylvania, we say pass outside the will. Okay. Meaning, even if I give this asset to John Smith, the will not designate that. It will not. Okay. And examples of some of those non-probatable assets are life insurance policies, Roth IRAs, 401ks, any other pension type retirement accounts, right? Yeah. Those are things that you need to be aware of. And I tell my clients this during every single meeting. I could say I give my life insurance policy with Ohio National to Kyle Ryan in my will, and Ohio National will laugh because the beneficiary is different than what's in the will.
Yep.
Okay.
Yep.
Your retirement accounts, your life insurance accounts, any other pension related accounts need to be solely designated by the beneficiaries. Yep. Right. So this kind of brings up a topic of, the husband and wife or the couple that has the second child, right? When they already had their first one. And, the only beneficiary designation under there is the first child. Right. We want to go back to our retirement specialists, right, or our financial planners or our life insurance agents, right, and say, look, I either need a new policy or I need to somehow change the beneficiary designations to make sure it encompasses everyone that is a part of my life now.
I have a horror story where a client changed his will, but he did not change his 401k. And at the time of his passing, he had been divorced. His ex-spouse got his 401k instead of his existing spouse, and talk about something I wouldn't even want to imagine.
And we're talking
unless I'm the ex-spouse.
That was going to be my next thing is the last case on when to update your estate plan is if you get divorced. That's what I was going to say there. I was waiting.
Absolutely.
You got it.
Absolutely. If you get divorced. And look, I see people too, fellas, that come into my office and say, my ex-husband, my ex-wife. And then the first thing I ask them is, do you have a divorce decree? And they say, oh, I need that? Yes, you absolutely need a divorce decree. And if you've been separated and you hold yourself out as divorced, there's different ramifications for how your ex-spouse can come at your will and actually take money that you don't want them to have, right? There's something called an elective share, okay, where an ex-spouse or someone that you're technically still married to but don't live with can actually elect a 1/3 share of your entire estate in Pennsylvania.
Wow.
Really?
Yes.
Never heard that. That's pretty scary to think of.
It's an incredibly scary thing, right? So, yeah. We have these conversations with these clients and saying, look, guys, let's talk about whether or not it makes sense for you to pay a little bit of extra money to make sure we finalize this divorce decree. I promise you, when it comes time to probating your estate, it will be cleaner and easier for you and your family.
Yeah. Yep. And I wanted to cover on one thing. We kind of got away from it a little bit, but going back to the titling of assets, right? If you have a beneficiary, if your will goes through probate, your assets go through probate, it could take weeks, it could take months for you to see the assets as an inheritor. Whereas if you
client of mine a year,
it could be years and years, right? Especially depending on the state you live in, right? Sure. New York, New Jersey, Florida, I've heard have terrible probate processes. But one thing that I very often urge clients to consider is if you have your bank accounts or your investments accounts in individual names, make sure that you have TOD or POD on them, because if your spouse needs that for funeral expenses or just their cost of living and they don't have access to it because they have to wait for it to go through probate, that can be a huge issue versus maybe a couple weeks if you have them listed as a beneficiary.
Yeah, absolutely. Transfer on death, payable on death, getting those in place are absolutely essential for that exact process, right? I'll often also recommend, if they're willing to do so, depending on how strong the relationship is, that husband and wife also share, joint accounts in a lot of instances. And
Yeah.
I think sometimes that is even more applicable for, the elderly, right? The men and women in their 60s, 70s, 80s, right? They may have some sort of underlying condition that they think maybe they're not going to be around as long as possible, right? There's no penalty for adding your spouse onto a bank account, right?
Yep.
Right. We can talk about Medicaid and different violations and look back periods and different things that can get you into trouble financially and with tax ramifications on a different date, right? But the reality is that when you put your spouse onto a bank account, right? Kind of all that, not all that dissimilar from putting your spouse on your property, right? That makes it easier for them to access your money. And when it comes time to probate, it's really kind of turns into a non-probatable asset. They've already retained that benefit because their name is on it.
Yep.
Yeah. The
Great
last
point.
thing I was going to say is I'm starting to do this a lot as well, is listing contingent beneficiaries, especially on any sort of investment or retirement account. Is having maybe a spouse as a sole primary, and then maybe having the children as contingents. Because that, my estate planner, my probate nightmare story is a situation where a husband had his spouse listed as the sole primary beneficiary on everything. He passed, and then within 2 weeks, his spouse was in hospice and wasn't able to sign the paperwork that we were trying to get out, and she passed. And then the daughter had to deal with the entire estate alone on her own, while also trying to grieve the passing of both of her parents in a 1 month period. That was also in the middle of COVID. So it was just a really tough time for her. And my thought is they could have completely eliminated this entire situation by just listing her as a contingent beneficiary on everything. Now, I'm not saying that's the perfect answer for every single client, because every familial relationship is different, but having some sort of primaries and some sort of contingents on any sort of investment or retirement accounts, in my opinion, is really important.
Always. Yep.
Absolutely. Can't speak to that highly enough, Thomas. And again, like you said, every familial relationship is different. I'll recommend it 99% of the time, though, to be honest with you, just to avoid that horror scenario that you just discussed, because we have seen them too. And let me tell you, it is a horror scenario.
Yeah. And especially too, the last one, I was going to kind of on that note on the trust side, because we don't need to get deep into trust because there's so much variability in that. But I had a client case where somebody came to me, they were a beneficiary of a trust, and they had a trustee that the owner of all the assets had passed away, and the trustee was actually in and out of the hospital for the first 6 months after the owner of the assets passed. And he was not able to actually process and move monies out of the trust and the estate. And luckily, the owner of the assets had listed this specific person as a successor trustee. And we were able to work with the estate planning firm to nullify the original trustee and pass the powers on to the successor trustee so that the assets could be distributed. And I think that if you get to a point of having a trust, having a successor trustee is really important as well.
Certainly. And that kind of, is very similar to the thought process behind having the alternate executor or executrix, right? It's, same story. We have these contingencies in place, not because we think that they're going to come to fruition, but unfortunately they do a lot of the time, right? And then, a lot of it deals with age or mental health or illness. And that's just the reality of the world that we're living in. We need to have these contingencies in place because we go through this process of drafting. I don't know, I'd necessarily say that all of them are complex, but some of them are complex. And we put a lot of thought into how we're doing this and why we're doing it. And then, to have it kind of a wrinkle thrown in there because someone got sick or isn't well or is incapacitated kind of throws everything out the window, right? So having those contingencies in place, I can't speak highly enough about that.
Yeah.
The good news is with a really good estate planning attorney like Sal here, you can make your trust, you can make your will. They're so customizable. There's so many things that you can do with them. All you have to do is speak with a good estate planning attorney, and they can do that for you. They can set up the successor trustee. They can set up the extra executor or executrix. They can add multiple POAs, right? Just in case. There's so many different things that common knowledge doesn't cover it. And that's why we really think that working with an estate planning attorney is, for most people, very important, especially for wills.
Yeah. And I think the summary of this episode, to kind of transition towards the end here, is you get out of college, if you go to college, or if you don't go to college and you start working, set up that will, set up the documents in place for your any sort of cash checking savings accounts. You get married, update that will, start looking at, updating beneficiaries as well. Maybe you got retirement plans in the picture. You start having children. Let's make some updates. You start having more children. Let's make some updates. Maybe you receive an inheritance from either of the spouse's parents. Let's make some updates. And I think the key here is laying the foundation early so that you can just make the quick updates as life is happening. And you don't have to scurry if something does come up. And just really considering the idea that you want to have all of this in place before something bad happens. And just the overall idea that, especially if you're working with a CFP, with a knowledgeable financial advisor, you can go to them and structure kind of the initial thought process, and then go to an estate planning attorney with a plan, and they can help you solidify and draft out the documents. There's just so much efficiency that can go into this. If you do it the right way, it can make your life a whole lot easier. And, Sal, I would just really appreciate your time on the podcast today. I think we've had so many good nuggets of information here. I hope everybody was able to listen through the whole thing, and, would love to just kind of get final thoughts if anybody has any.
Sal, if you could just tell people how to reach out to yourself. I really thought this was great. Sal, I could spend another 2 hours talking about, there's so many things that we didn't cover that we could have. So we'll see what happens in the future. But if you could tell people how to reach out to you, anything else you want to add like that?
Yeah, no, absolutely. Thank you both so much for having me on. Right. We only scratched the surface of all the things that we could touch on in this episode. Right. It's a situation where there's a plethora of other things that we can talk about and other intricacies that go into this. Right. But it's a learning process. Right. And it's also one of those things. And one thing that I neglected to say that I think we really need to leave on this, on this last point. And then Thomas, kind of discussed it with the timeline of your life. Right. So many people come in and they think that once they get their will done, they're good, right?
Yep.
You're not, okay? You acquire more property. You have kids. There's deaths. You get divorced, right? You need to come back and update it. And let me tell you, you choose me, you choose somebody else, your initial fee for your estate planning attorney is going to be whatever it is. Some will charge more. I think we're a little bit more competitive. I won't go into our rates. But the point of me telling you this is that once you stick with that attorney and they draft your initial documentation, I promise you it's going to be significantly cheaper. And in fact, you'll be shocked how cheap it is to make updates, because these attorneys want your business and they want to make sure that your estate plans are right. Because when it comes down to the end of the day, it's them that are going to be in trouble if they didn't draft it the right way.
Yeah, absolutely. And I was even going to say, and we just keep thinking of stuff, but even looking at benefits at your company, I've had so many clients where I've analyzed their company benefits, and there's some sort of estate planning discount. And a lot of the estate planning attorneys in any city or state will be plugged in with those benefits and can get lower reduced costs on setting up an estate plan. So definitely consider that as well. But Sal, I really appreciate your time. And we're going to make sure whenever we get this posted out, whether it's YouTube or LinkedIn, that we've got your contact information. We'll make sure and tag you and link on LinkedIn. Thank you so much for your time, Kyle. Thank you so much as well. If anybody has questions, thoughts, or ideas for the podcast, please feel free and reach out. We've got all of our social media and outreach tags on YouTube and LinkedIn, and really excited for the next episode. Thanks so much.
Thank you guys so much. I really appreciate it.